Hey everyone, my name is Matt. Today we're talking about something that's never easy, selling a home that you've inherited after the loss of someone you love. I know this can feel overwhelming emotionally, legally, and financially, and you're not alone in trying to understand what comes next. Let's walk through it together with clarity and compassion. Have you ever wondered, do I even have the legal authority to sell an inherited property in Florida? Do I need court permission before I can take that next step? This is one of the first and biggest questions that families face, especially when that house represents memories, history, and often a lot of emotion. Or maybe you've thought, I just want to do what's right. Is there a way to sell without being tangled up in months of legal red tape, especially when I'm already dealing with grief? It's a real concern. You want to honor the legacy of your loved one, protect your family's interests, and move forward with peace of mind. Well, here's what I can promise you today. You can sell an inherited property in Florida, but whether you need court approval depends on how the property was owned and how it transfers after death. I'm going to simplify the process so you know exactly what to expect without legalese or guesswork. First, you want to determine how the property was held. If the property belongs solely to your loved one and didn't pass automatically to another owner through a trust or a joint deed, it must go through probate. This means the court needs to appoint someone, usually called the personal representative, to manage the estate before any sale can happen. And yes, in most typical cases, that does mean court approval before the sale closes. What if it avoids probate? Well, good news, some ownership structures sidestep probate entirely. If the property was held in a revocable trust, if it was owned as joint tenants with right of survivorship, or through an enhanced life estate deed, also known as a ladybird deed. In those situations, ownership passes immediately when the owner dies, and you often don't need court approval to sell. If probate is required, here's what happens. When probate is required, Florida law says you must get letters of administration from the county. The court reviews it to make sure everything is fair and in the estate's best interest. This process protects the rights of creditors and heirs, so no one is left at risk, even though it can feel slow and frustrating. What about homestead property? Here's a special point. If the inherited home was the person's primary residence or their homestead, there may be extra documentation and court steps required before title companies will ensure the sale and close the deal. That's not meant to make things harder. It's meant to protect surviving spouses or minor children who have constitutional rights to that property. So let me say this clearly. You don't need to figure this all out alone. Whether you're feeling overwhelmed by legal jargon, the probate process, or just the emotional weight of selling a home tied to so many memories, it's okay to ask for help. That's exactly why we talk about this stuff openly and support families every day. If you're facing this situation and you want clarity about your next best step, drop a comment or reach out. I'm here to help you navigate this with confidence, respect, and understanding. Thanks for tuning in, and if this helped you today, share it with someone who might need this reassurance.